Nidhi, am I audible?
Hello. Yes,
Okay, okay, okay.
yeah.
Okay, so starting with CSMB introduction. So I'm going to present, starting the presentation. Okay. So I request everyone to please mute themselves to avoid the disturbances during the webinar. So Chamber for Advancement of Small and Medium Businesses works towards empowering micro, small and medium businesses. Uh, my presentation is visible, Nidhi?
Yes.
Okay, all right. It's not moving ahead. Just a minute, give me a minute. Okay. So, Chamber for Advancement of Small and Medium Businesses works towards empowering micro, small, and medium enterprises. CSMB assists SMEs in developing products to cater to global market. We have strong advisory team. Also, here is mission of CSMB to work closely with stakeholders for advancement of micro, small, and medium businesses. Our vision is make MSMEs more resilient and make them stronger backbone of Indian economy. These are some objectives of CSMB. Uh, Here are some social media handles. You can follow us through Facebook, Instagram, LinkedIn, and YouTube. This is Purna Brahma magazine. So Purna Brahma magazine is an initiative of CSME. It is a quarterly magazine which allows stakeholders to advertise their brand. Uh, Food Tech Pathshala is a skill-based e-learning platform, especially curated for food tech students and industry professionals. Uh, CSMB organizes various seminars and webinars. FI India event in 2022 or CSMB and Ramp Up Advisory LLP exclusively organized FundQuest program at FI India exhibition. 6 startups participated and four investors pitched them. CSMB and MSME Z certification awareness program in Mumbai and Pune. Pitch Folk event in Dubai. Seminar on California ingredient. These are some webinars. International Millet Year of 2023. National Seminar of Business Development of MSME of Nandurbar district. National Seminar for Business Development of MSMEs, Nandurbar district. Asia's largest CMPL Expo. Chamber is international pavilion partner for that. Chamber for Advancement of Small and Medium Business was a major co-organizer for AnuFood India 2022 and 2023 event. These are some glimpses from FundQuest pitching opportunities for startup at FI India 2023, which is in Mumbai. These are some glimpses. So our upcoming event is CSMB Foundation Day, which will be happening on 1st March 2024. This is the contact details of our president, Mr. Nilesh Lele, sir. You can contact through the email ID. So handing it over to Nidhi ma'am. Nidhi ma'am is going to introduce our today's speaker. So handing over to Nidhi.
Thank
Hello, Nidhi ma'am, are you there? Nidhi?
in the HR and finance sector, and he is the partner at Serve HR Corporate Services. He His core competencies include statutory compliances, audits, labor and employment law, internal audits, and portfolio management. Joining us alongside Mr. Joshi is Mr. Arvinder Singh Tanwar. He is a director at Serve HR Corporate Services. A very warm welcome to the webinar, sir. Without further ado, let's embark on this journey of knowledge. Over to you, sir. Thank you.
Yeah, hi, good afternoon, everybody. This is Arvindra. So I represent Serve HR Private Limited as a director sales, and I have been a labor law consultant since last 3 years. And more about Serve HR. So we are an industry expert in labor laws compliance field for last 4 decades now. And to speak more on this today's webinar, I have my director partner, Mr. Mehul Joshi, also. So he'll give a brief presentation on understanding of labor laws compliances. Mehul sir, can I request you to please start?
Yeah, hello, good afternoon. I need a permission to share the screen or
Yes, just a minute. Yes, sir, you can share now.
is the screen visible now?
Yes, yes.
So I will be running you through today to the understanding of the labor law compliances to the audience. We'll start with the Employees Provident Fund Act. So there are around 15 labor laws that we've covered in today's presentation, and I will be eventually giving you a small gist of all these labor laws, which is the purpose of the act, the applicability summary, etc. So now, Provident Fund is a social security scheme, which is a central government scheme which encourages compulsory retirement savings for the employees. The act becomes applicable to the companies where there are 20 or more employees. For the count of these 20 employees, the directors who are also drawing salary from the company are also included. The scheme has a mix of savings as well as pension. So there are two schemes which run parallelly, which is the Employees Provident Fund scheme and the Employees Pension scheme, where the aim is to provide a monthly income after the age of 58 years in the form of a pension to the employees. The contribution for the scheme from the employee salary is 12% of their basic salary, and the employer contribution is also an equal contribution. So as you can see on the screen here, the 12% of the employees contribution goes into the EPF, which is used as a lump sum for giving a compound interest to the employees. And from the 12% of the employer's contribution, 3.67% goes again into the PF fund. So technically, out of 24%, 15.67% goes into the PF fund and 8.33% goes into the pension fund. Now, this pension fund is a fund that the employee is going to receive on his retirement as an equated monthly pension amount. There is no interest given on this pension. However, there is an additional central government contribution on the pension scheme. The eligibility for pension for an employee is 10 years of continuous service. And there is an EDLI cover in addition to the pension, which is 7.5 lakh rupees in case of a death of an employee. So just in case if an employee died during the service, even if it is a natural death, the employee will get 7.5 lakh rupees as a insurance from the pension scheme of the government. In addition to that, the employee will also receive a monthly pension. The nominee will receive also a monthly pension. This is the basic summary which I had explained you. 12% employee contribution, 13% employer contribution. The applicability is 20 or more employees. The salary cap for enrolling in PF is 15,000 or below. for the employees who are drawing above 15,000, it is an optional scheme. There is also voluntary contribution permitted, which is up to 100% of the basic wages. The next is the second major social security scheme run by the central government is the ESIC Act. The purpose of this act is purely on a layman perspective, taking care of the medical needs of the employees. The act becomes applicable to an establishment once they have 10 or more employees. This, the advantage of having an ESIC for the establishment is that there is no liability of providing medical benefits or medical insurance policy for the employer. The employers are also exempted from the liability arising under Maternity Benefit Act and Workmen Compensation Act. To the employees, the benefits are six major benefits. One is the sickness benefit, which we call it as a loss of pay. So hypothetically, if an employee does not attend attend his office because of sickness, say for example, if he's not attended for 5 days, so there is a loss of pay to the employee in terms of deduction of the salary. So ESIC in this case reimburses 70% of the loss of pay to the employee directly into their bank account. So that is a sickness benefit under this policy. Second is the medical benefit, where the medical treatment of the employee is free of cost. He can consult a doctor. The medicines are also given free of cost from the registered ESIC medical stores. The third benefit is the accident benefit, where in case of an accident during employment, the medical expenses, the employee can be admitted to the nearest ESIC hospital where the treatment is free of cost. The fourth one being the maternity benefit, where the obligation of paying of maternity benefit, which as of now is 6 months salary to the employee, is taken care by the ESIC corporation. So there is no need of an employer to pay the maternity benefit to these employees. The fifth one is the disability benefit. So disablement benefit arises where typically in case of factories where there is an employment injury which results in a fatal injury and disablement of the employee. So basis the disablement percentage, the ESIC gives a disablement benefit. So hypothetically speaking, if the employee was drawing a salary of 20,000 and if he is 30% disabled, it could be loss of hand, amputation of leg. So ESIC will pay the disablement benefit, which is 30% of his wages, which is 6,000 rupees to the employee month on month basis, as long as the employer has uh, hired him and also paid ESIC for him. The most important and the most major benefit under ESIC is the death benefit for dependents. So this applies in case where the employee, as a result of an accident or a result of an employment injury, dies during the service. So the ESIC would pay 90% of the salary of the employee to the dependents for the lifetime of the dependents. So this is the most major benefit that ESIC provides, which no insurance company provides today in India. So, and the last other two benefits which are of lately come into ESIC is the cashless super specialty treatment tie-up, where ESIC has tied up with private hospitals in cases where ESIC does not have the medical machinery to attend to these employees or to give treatment to these employees. So a major private hospital like Fortis, Platinum, etc., if you talk about Bombay, are a part of the ESIC tie-up, and employees can be admitted to these hospitals free of cost, and ESIC pays the hospitals for the treatments. The summary of ESIC in terms of the contribution is 3.25% from the employer contribution and 0.75% from the employee. So for a salary of 10,000 rupees, 325 rupees is the premium that the employer has to pay for getting all of these benefits. Salary, again, this is applicable to employees whose salary is less than 21,000. Every employee that enrolls in ESIC is issued a medical identity card, which is more like a cashless mediclaim card given by the central government. I have explained you the benefits in the previous slide. From a compliance perspective, it is monthly returns, challans, records, musters, etc., which is more of an administrative compliance. Next is the Labor Welfare Fund. Again, this is also a welfare scheme, but this welfare scheme is of the state government. This is basically applicable to the establishments who are having 5 or more employees. And this is more of the scheme is for the labor category of employees, which is the non-managerial employees. The responsibility of the employer here is to contribute to the labor welfare fund and disseminate the information of the welfare activities taken by the state government. So the state government periodically takes up the welfare activities like recently there was a free driving school where the employees can enroll for learning to drive a four-wheeler motor car, and the fees that they pay for this is going to be the reimbursement. And then there are gymkhanas at various places in Maharashtra, the prominent being one in Lower Parel in Maharashtra, where the employees can use the facilities of a swimming pool, a library, and other activities. So this is more of a welfare scheme, which is by the labor welfare, but the employer is obligated to contribute towards this scheme. The fourth one again is a Payroll Compliance Act, which is the State Profession Tax Act. There is not much here because this is more of a taxation which the government collects from the employer, where the employer is obligated to deduct a particular amount from the employee's salary. Uh, Currently, it's 175 rupees or 200 rupees, depending on the slab of the employee, and pay it to the state government of Maharashtra. Uh, The next one is the Shop and Establishment Act. So, Shop and Establishment Act is an act which basically governs the employment conditions of the employees. So, things like the working hours, working days, leaves, holidays, etc. So, all of these are governed by this Shop and Establishment Act. The act talks about what should be the working hours, how much should be the maximum overtime given, what are the conditions of part-time employment, what are the conditions of making women working in the night shifts, etc. So this is more of an informatory in nature, this act, where the guidelines mentioned in the act have to be followed by the employer. Typically, what people understand about this act is that you have to take a shop and establishment certificate and it ends there. But there are beyond that, there are other responsibilities of the employer, which is the display of abstracts, notices, your registration, renewals of licenses. There are certain registers to be maintained, and annual return filing, which is a part of this act. The next is the Contract Labor Act. The the whole purpose of the act is the regulation and abolition of employment of contract labor. So this typically is applicable for establishments where they are engaging 50 or more contractual employees. So the typical audience could be a factory, a construction site, or a larger infrastructure project where there are a lot of contract labor engaged. The responsibility of the employer here is to adhere the provisions of the act. So what this act emphasizes the same working conditions which are there in the Shop and Establishment Act, a few addition to that pertaining to the contractual labor employees. And in addition to these provisions, it also emphasizes on the employer to maintain certain registers, records, and timely intimation to the authority related to accidents or any such event on the construction site or even in the factory premises. Next is the Factories Act. As the name suggests, it is typically applicable to the Factories Act. So, unlike Shop and Establishment Act, which is applicable to the employees working in commercial establishments and shops, the Factories Act is the act which applies to the employees working in a factory. Now, the when we say the what the act talks about, the act talks about the same thing what Shop and Establishment says, which is the working conditions of the employees. Again, working hours, overtime, night shifts, leave rules, etc. But since it is a Factories Act, in addition to the things that are mentioned in the Shop and Establishment Act, the Act also extends to safety compliances, which is the machinery placement, the fire exit, the examination, medical examination of workers, machine testing, etc. So there are typically two types of compliances under the Act. One is what we call it as a technical compliance, which is more to do with maintenance of machinery, the placement of the machinery, the fire exits, testing of your machines, etc. And the administrative compliance, which is more to do with the register record maintenance, the leaves, working hours, adherence, all of those things. So any factory which is having 20 or more workers and working with an aid of power, or 40 or more workers working without an aid of a power, is governed under the Factories Act, irrespective of whether the establishment has taken a license under Factories Act or not. The next in line with the Contract Labor Act is the Building and Other Construction Workers Act. This is typically applicable to the construction workers who are working under the for the construction of building or the infrastructure projects. Now, the need to get in this act, in addition to the Contract Labor Act, was for the welfare of these construction workers. So I am not aware if many of you know about it. That there's a 1% cess which the construction companies pay for the value of the project that they construct wherever. So this 1% cess which is paid to the local authority is used under the Building and Other Construction Workers Act for welfare activities of these construction workers. From a welfare perspective, what the act does is it provides for safety equipments to the workers. It provides for the food, and the food which is to be supplied at the site. So the government, the employers need to register under this act and approach the local labor department, and the local labor department then provides for the safety equipment, and there are periodically many welfare schemes that come along. So that is the benefit that the employer can take from the government department under this act. The next is the Minimum Wages Act. As the name suggests, it enforces the payment of minimum rate of wages and the related conditions related to the overtime and the weekly holiday overtime in case where an employee is required to work on a rest day. Every 6 months, the state government issues a minimum wages chart where if the basis the inflation and the CPI index, the minimum wages are increased, and the employer is under an obligation to ensure that no employee is engaged below this minimum wages. As we speak today, the minimum wages today in Maharashtra for a skilled employee is somewhere close to 14,000 rupees a month, and this keeps changing every 6 months. That is in the month of July and in the month of January. The next in line is the Payment of Wages Act. Again, the act talks about fixing of the wage period, because there is a payment of wages that is done to the employee. So the minimum wages takes care about how much should be the wages. The payment of wages talks about when these wages have to be disbursed. So the under the Payment of Wages Act, for employer having less than 1,000 employees, the payment date given is 7th of the following month, and for the employers having more than 1,000 employees, it talks about 10th day as the date of payment of wages. Again, from a perspective of responsibilities of the employer, there's an administrative compliance of maintaining certain registers, certain returns, etc. Next is the Employment Exchange Act. So now here under this act, for every establishment which is having 25 or more employees, the government wants you to notify the vacancies that occur in an establishment. So hypothetically speaking, if you are looking for, say, hiring an accountant, and in case if you have an employee strength of more than 25 employees, the employer is under an obligation to notify the local employment exchange about the job openings that they have. The local employment exchange will try to connect you with local aspirant employees who are looking for jobs in that particular profile. However, there is no obligation for the employer to hire these employees from the local employment exchange, but the obligation remains restricted to notifying the vacancies that occur to the local employment exchange. Next is the Maternity Benefit Act. again, this act becomes applicable to establishments having 10 or more employees. The act uh, is basically for the working female employees who undergo maternity, where the employer is obligated to provide them leaves with wages for 26 weeks. So this was 13 weeks earlier, is now amended to 26 weeks. So 26 weeks is almost 6 months. However, if the employee is covered under ESIC, then there is no obligation from the employer to give this benefit to the employee, because the ESIC department then gives a 6 months of salary to the employee. But for all the other employees who are not covered under ESIC, the employer is under obligation to provide for this leave. One more important thing is it is clearly restricted under this act that the employer cannot terminate the employee once she reports that she is eligible for a maternity benefit under the act. So that restricts and creates issues around this act for most of the employers today, where there is a large women workforce in the establishment. The next is the Payment of Gratuity Act. Again, this act talks about paying a certain sum for the loyalty of the employee for the tenure of in the organization that he or she has served. The act becomes applicable to every company which is having more than 10 or more employees. The obligation of the employer or the responsibility of the employer is to pay gratuity amount to the employee once the employee completes 5 or more years of continuous service, or in case of a death, the gratuity payable to the employee, irrespective of whether they have completed 5 years or not, is to pay them on a pro rata basis. From the compliance angle, one is definitely the payment of gratuity, and second is the record maintenance around that, where you need to prepare and file a notice to the labor department as and when a gratuity case arises to the establishment. Next is the Payment of Bonus Act. Again, the purpose of the act is to reward the employees by sharing the profits linked to productivity. Now, the Bonus Act is applicable to every establishment having 10 or more employees. However, there's a 5-year infancy period in case of a loss-making employer. So that typically means that if you're a startup and you've not achieved profits within the first 5 years, there is no obligation to pay bonus. But however, if you achieve profit within the first year or second year, the Bonus Act becomes applicable to the establishment. The Payment of Bonus Act is basically minimum 8.33% of the basic wages or the 20% of the basic wages, depending on the profits of the establishment. So the government here wants you to distribute the additional profit, the surplus profit that the establishment arises in the form of bonus, which the minimum is 8.33% irrespective of the profit, and the maximum is 20% depending on that. Besides that, as for all other acts, there is administrative compliance of maintaining certain records and filing returns under this act. Next is the Equal Remuneration Act. Now, the purpose of this act is to pay equal remuneration to men and women working in the same job. However, in today's world, this is more of become an obsolete act, because back in the days, there was a concept where the female worker was paid less salary than a male worker. So to ensure the legal rights of both the genders, this act had come into the place. However, in today's world, the salaries are completely dependent on the experience of the employee, and therefore the enforcement of this act has become impractical as in today's world. However, the act still remains, and the compliance also is the administrative compliance is something that we do for our clients. Next is the Employees Compensation Act. Now, this is one act which is applicable. This was recently amended in the state of Maharashtra, and this has become applicable to every establishment, even engaging one employee. Now, what this act talks about is that the employer is under an obligation to obtain an insurance under Employee Compensation Act, where the payment of compensation to the employees in case of a fatal injury, death, or funeral expense of the death is taken care of. So under this act, any employment related injury, if it is fatal in nature, there is a compensation methodology, which is a mathematical calculation of the compensation, which is prescribed under this act. and the employer is under an obligation to avail a insurance policy for taking care of the compliance of this act. So this is one act which is applicable to almost everybody, but most of the establishments are not aware about the applicability of this act. The next is the Maharashtra Workmen Minimum HRA Act. Now, the purpose of this act is to provide a minimum housing allowance to the employees. However, this is applicable only to establishments or factories employing 50 or more employees. So here the obligation from the employer is that whatever is the basic salary of the employee, a minimum of 5% HRA allowance has to be given over and above the basic salary of the employees. So the minimum is 5% or 20 rupees, whichever is more. So hypothetically, it is 5% HRA compulsory payable in the state of Maharashtra. One is the payment part of it, and second again is the register record maintenance under this act as a responsibility of the employer. The next is the Interstate Migrant Workmen Rules 1981 Act. Now, this act is aimed at regulating the employment conditions of the migrant workers which come inside the state of Maharashtra. So here the act talks about the obligation of an employer to provide paid leaves to such migratory workers to go back to their hometown every 6 months, and also the conveyance allowance toward it, leave with wages, and the working conditions that may be required to be given to the migrant workers. So again, this is act is more relevant for manufacturing setups, construction sites where there's a lot of migratory workforce that comes into the state. And the address on the Aadhaar is the basic criteria of deciding whether the person is a migratory employee or a non-migratory employee. So this was all about the 16 acts of labor law that we've gone through. If there is any question and answers, you can go ahead and ask. I'm done with the presentation.
I think there is no questions as such, so we will move ahead. Nidhi, over to you.
Yes. Thank you all for being a part of this webinar today. Before we I want to take a moment to express our sincere appreciation to our speaker. Sir, your insights on the topic were nothing short of enlightening. We are truly grateful for the time and efforts you have dedicated to sharing your knowledge with us. And once again, thank you so much, sir, for being with us.
Thank you.
Thank you so much.
Thank you, Nidhi. Thank you, Mehul sir, Arvindra sir.
Yeah, thank you.
Thank you, participants.